Hi, everybody. We're going to get started now. Welcome. Thank you so much for joining us today. We're really glad that you could make it to our webinar about child support in arrears in New York. So if you are a parent or a caregiver who's going through family court right now and you're looking for information or guidance, welcome. We're really glad that you could make it and join us today. If you're a service provider or an individual who's interested in learning more about family law, welcome. We're also really glad that you're here. So this is our second webinar. Our first webinar is on our YouTube page, and it is about basic family law information in New York, including child support, custody, visitation, paternity, and orders of protection. So if you have any questions about custody, visitation, or the other topics we're not covering today, you can check that webinar out or give our helpline a call. We'd love to help you out with that. So one other note before we get going, we've done our best to iron out any tech problems, but if we run into any, we would really appreciate your patience as we resolve that. So we're going to introduce ourselves and then get going. Hello, my name is Hilly Teller and I manage LIFT's community outreach efforts.
Hello, my name is Ryan Gallagher. I am in charge of a bunch of technology around the office, but I'm also the attorney in charge of our legal helpline services.
Hi everyone, I'm Molly Burke. I am the Bronx staff attorney.
Great.
Hi everyone, my name is Marina Rio. I'm a bilingual program associate.
So we will be sharing more information about LIFT's programs at the end of the presentation today, along with information about OCSS, the Office of Child Support Services, and ICSU, the Interstate Child Support Unit. But if you have any questions, if you have to leave early today, or questions that come up after our webinar, you can always call our helpline or live chat us or email us on our website. So our helpline number is here. And our helpline's open Monday through Friday, 9 to 5, but we're closed an hour for lunch from 1 to 2 o'clock, just so you're aware. Okay, so today we will be talking about child support in arrears. We're going to start off with Ryan's going to take us through some updates about family court during the current public health crisis, what's going on there. And then Molly's going to walk us through the basics of an introduction to child support, including paternity, calculating child support, and all that. And then Ryan's going to share information with us about modifying a child support order and enforcing child support in New York State. And then, like I mentioned, we'll share some resources and information on where to go for help. A few notes on how to participate in this webinar. We really encourage you to. It helps us out a lot, and it's a way to stay connected to you all while we're all separate and in our respective homes. So there are 3 ways you can participate. You can submit a question to the Q&A box, you can raise your hand, and you can also chat with us, the panelists, if you want to introduce yourself or if you're having any sort of issue. A note about the Q&A box. The button is here at the bottom. It says Q&A. Please submit your questions there because it will allow us to see all the questions together when we get to our question and answer section. Another cool function of the Q&A box is all of the questions that have been answered live will show up in there. So if we answer a question and you want to go back and see what the question was, you can always click on the Q&A box and it should show up there for you. If you're having an issue or if you've chatted us and we haven't responded, you can just raise your hand. And then when you're done, just take it down. It's a pretty simple thing, but we like to see it. I know a few people have their hands raised right now. And then finally, you're welcome to chat with us. Just so you know, the chat doesn't go to all the participants. It just goes directly to us. So please engage with us. Let us know where you're from, what brought you here today, any information you'd like to share. So we're going to start today with a poll, and we'll have a couple polls throughout the webinar. But this first poll is what brings you here today? Are you a parent or a caregiver who is here for legal information? Maybe you're a service provider or you're just here to learn about family law. And what topics are you most interested in learning about? So as I mentioned before, we have family court changes during COVID-19. We have paternity, information about child support, including modifying a child support order, enforcing a child support order. And we will be covering information about arrears or unpaid child support. So I'm going to close the poll down in about 5 seconds. So wrap up your polling, and then we'll share the results with everybody. All right. Okay, great. So welcome. We have a lot of service providers here. I'm glad to see that. We have folks here who are here to learn about LIFT and learn more about family law, and also parents and caregivers here for legal information. And thankfully, everybody's interested in hearing about child support because that's what we're here to talk about. So I'm going to pass it on to Ryan now to give some updates about family court.
Okay, welcome everybody. Thank you for joining us today. I'm sure, I know everyone, well, a large part of you are here for information about child support, but I imagine that in some way you have questions about how that's working out with COVID-19, because just like the rest of the world, the family courts in New York have been affected by the lockdown that's taken place in New York. So the information that we have is relevant or is up to date as far as today. And so that's what I can provide to you. As far as what will happen in the future, I may not have the answers for that, but we can talk about it. So next slide. As of now, what's going on in family court? Well, right now they have opened for court staff only. They are still not open to the public in the New York City area. As far as court cases go, they are not accepting any new petitions, except for emergency petitions. And let's explain what that covers. Next slide. So emergency matters are cases that are dealing with abuse or neglect, juvenile delinquency, orders of protection, and some custody and visitation cases, generally when the child's safety is at risk. Likewise, they are starting to hear cases that were already calendared. So they had scheduled court dates and were in the middle of a trial. They have started to hear those, but even those are being heard virtually. As of now, there are no cases taking place live in the courtrooms of New York City. Finally, the last big thing that's happening is that child support modification requests can be submitted at this time. And we'll go over a little bit about what that means. But the important thing to note is, even though you can file this petition or this request for a petition, excuse me, they are not scheduling hearing dates yet, but you can get the paperwork into the court and kind of preserve an important date that we'll mention. As far as this information, if you have questions about it, about changes, there are a couple resources for you. Of course, you can go to the New York Court's website, and they also have a phone number that you can call. But I would also say you can reach out to our helpline. The helpline number is listed on the slides, 212-343-1122. And it's listed throughout every slide. Give us a call if you have questions for updates. And we'll try to, we're in contact with the court every day, trying to figure out what's going on, and we can relay that to you. Likewise, with the child support modification requests, if you have questions about that or looking for a little bit of aid in that process, give our helpline a call. And we're happy to walk you through it. All right, next slide. So, are there any questions related to what I just said? If there's questions about child support and modifications and all that, we'll deal with those later on. But if there's questions dealing with the court's opening and access, I'm happy to answer those.
Hey, Ryan. Thanks so much for that and for going through that. Right now, we don't have any questions based on what's going on with the courts right now and the public health crisis. Mm-hmm. There are some questions, but let's hold them off until later.
Okay, that's fine.
And if I could add one thing, we will be having an extended Q&A at the end of the webinar today. We're going to try and move through the presentation. We'll take a couple questions throughout, but please stick around after 4 o'clock, and Ryan and Molly will be sure to get to all the questions submitted.
Definitely. All right, well, if there's no questions on that topic, then we're going to move into the child support section. And I'm going to turn it over to Molly, our staff attorney in the Bronx.
Hi, everyone. Thanks, Ryan. So welcome again. Thank you so much for coming. I see a lot of friendly faces and some new faces, so it's great to meet you all. So we're going to be walking through child support as if we're walking through the timeline of an actual court case. So we'll be starting with filing a petition and make our way all the way through the final order of filing objections, and then I'm going to hand it back over to Ryan for modifications and enforcing child support orders. So keep an eye on this timeline above right here. We're going to be filling it in as we go. So let's jump right in. What is child support? It's financial support, food, shelter, clothing, basic necessities provided by the non-custodial parent, the parent that the child doesn't live with the majority of the time, to the custodial caregiver, the person who the child does live with most of the time, or to the Department of Social Services. It also includes add-ons and things for health insurance, healthcare expenses, and can include childcare. So before we even start a case, I want to file, or a case has already been started against me. What are some good things to know? Next slide. First, how long does child support last? In New York State, child support goes until the child is 21 years old, unless there's an emancipating event, such as the child joins the military. And we'll talk about this a little bit more later. Other states may be different. The child support may go until 18, but in New York, and that's what we're talking about in this webinar, New York child support goes until 21. Can I get a lawyer to represent me? Generally, no, there are no court-appointed lawyers for child support cases, but there are 2 times where there can be a court-appointed lawyer on the case. The first time is where there's a violation case and you're the non-custodial parent, the parent that the child doesn't live with for most of the time, and you're facing possible incarceration. That's when you could get a court-appointed attorney to represent you. The custodial caregiver, however, will not be appointed an attorney. The second time is when it's a Department of Social Services case with public assistance, and that's something we'll talk about a little bit later as well. Now, what about custody and visitation with child support? Is the court going to decide both of them together? No. These are completely separate cases, and they're heard by separate jurists or separate judges. A jurist is someone who's going to hear or decide the case. Child support is generally decided by a support magistrate, whereas custody and visitation cases are heard by judges or court attorney referees. Next slide. How long does a child support case actually last? The case itself. Well, this can take up to several months, and you saw at the beginning we had that timeline up. This is going to take several court appearances, and everything can't be done in one day, unfortunately. So it usually takes at least several months to finalize a court order. Now, who can file for child support? And we've got a poll. So is it just mom, just dad, mom or dad? Can it be whoever the child lives with for most of the time? Can it be anyone? I'll give you guys just another minute, a couple seconds to answer. Okay. Okay, and let's see some results. All right, all of the above, 72%. Awesome. Yeah. So, next slide. It's not just mom or dad. The custodial caregiver, whoever the child lives with for most of the time, can also file for child support. The child themselves can file in certain circumstances. And the Department of Social Services can also file for child support if the child is receiving any public assistance. So when a child is receiving public assistance, the Department of Social Services will automatically start a case against the non-custodial parent, the parent that the child doesn't live with for most of the time. It's important to know that The Department of Social Services are the ones that are going to receive the child support order, not the custodial caregiver. But there can be something known as a pass-through. This is something where the custodial caregiver can receive a portion of the child support, but there can't be any arrears owed, and it has to be, the child support order has to be more than the DSS budget letter. Also, if there are any concerns with domestic violence and you're the custodial caregiver signing up for public assistance, please speak with your caseworker when you're applying for benefits. Next slide. Awesome. So now we know some really important things before we even get into court. But then we want to start a case. We want to file a petition. And filing a petition is a way to get a court date to go in front of a jurist. This is the very first thing that the custodial caregiver or agency, DSS, is going to do. Once the custodial caregiver or the DSS files the petition, they're going to have to serve the respondent. The respondent is the person that the case is against. The petitioner is the person that starts the case. How do you do service? Generally, it's through personal service. This is actually handing the papers to someone, and it has to be done by someone who's over 18. It can't be someone who's a party to the case, so not the petitioner, not the respondent. And it has to be at least 8 days before the court date. So let's say I want to start a case against Ryan, and I filed a petition, and now I've got these papers, and I need to have him served. So I'm going to call my friend Hilly. Hilly?
Hey, Molly.
Hey. So I'm trying to start a child support case against Ryan. Would you mind serving him for me?
Sure, I could do that.
Awesome. Okay, so here are the papers.
Got him.
Great.
Okay, I'll go serve Ryan. Hey, Ryan. I'm knocking on your screen.
Hey.
Ryan, that's you, right?
Yeah. Who's asking?
I've got something for you. Here you go.
What is this? I don't want this.
Thanks, guys.
No problem.
So this is just a way to demonstrate how personal service works. It has to be in person, but even if Ryan doesn't want those papers, he's been properly served. And Hilly could even leave those papers in his vicinity, like at his feet, and it still counts as proper service. Next slide. So instead of using me and Ryan this entire time, we're going to use my friends Maria and Robert. So I'll give you all a minute just to read through Maria and Robert's situation. Okay, so Maria wants to file for child support against Robert. What does she do? She's filed the papers, she's had him served. We're going to use them to work through how to start a case, and even through if they want to modify or object to the court order. And up here on the upper left hand it's called a case caption. This is usually on the summons, and it's always on the summons and petition. It's Maria, the person who starts the case, is the petitioner, and Robert is the respondent, the one that is the case is against. Next slide. So we filed the petition and we've gone through service. We go into the first court date. Maria goes in. Whoop, hang on one second, guys. Okay, we've started the case. We filed the petition. We've gone through service. Maria goes into the first court date, and the support magistrate asks for something called the affidavit of service. So an affidavit of service is a way for the support magistrate to check that the respondent is properly served or notified of the case. The affidavit of service is something that has to be signed and notarized by the person that serves the respondent. So in my example with Hilly and Ryan, Hilly would be the one signing it and getting it notarized, and then she would give it to me. I would then give it to the support magistrate to make sure, so that the support magistrate could make sure that Ryan was properly served and notified of this case. But what if the respondent wasn't properly served? The support magistrate cannot move forward with the case if the respondent hasn't been properly served. And the affidavit of service makes sure that this happens. But if the respondent has been properly served, then the support magistrate may be able to move forward without them. And that's something that we'll talk about. Next slide. Okay. So if you're keeping an eye on this timeline, we've already gone through filing a petition, service, the first court date. After the support magistrate makes sure that the respondent was properly served, they have to establish paternity or make sure and determine who is the legal father of the child or the children. So that's what establishing paternity means. It's determining and proving who that legal father is. In our case with Maria and Robert, they were married. So how is paternity established? Next slide. There's 3 ways to establish paternity. The first way is marriage and the presumption of legitimacy. The second way is through an acknowledgement of paternity and the AOP, commonly referred to as the AOP. And the third way is through a court order of filiation. We talk about paternity a lot on our first webinar, so I'm going to encourage people to go back to our first webinar and watch that to learn about how the court establishes paternity. I do want to just highlight that there's something called equitable estoppel. This can actually prevent someone from challenging paternity. But again, check out our first webinar. We dive into paternity more with that. And the AOP, I see a question. The AOP is the acknowledgement of paternity, but it's people usually refer to it as an AOP. Next slide. All right, let's pause for some questions.
So there are a couple of questions that I think might be appropriate. So the first question we have is, what can you do if you attempt to serve somebody and they're not at home or don't answer the door?
Ooh, that's a really, really good question. There's something called alternate service, and that's something that we can work through. If you call our helpline, we can work through. Instead of personal service, it could be service by certified mail, but this has to be something that's approved by the support magistrate or jurist or judge or court attorney referee on the case. But call our helpline and talk to us more about that if something like that is going on in your case.
All right, and one more, because I think it'll be quick. If someone doesn't have a laptop to be able to do the DIY forms, are there other ways that they can file for child support?
If they don't have a laptop, like do you mean the requests for modifications?
Yeah, I guess.
Oh, yeah.
I'm not sure, but I'm guessing since that's what we mentioned earlier.
Sure. So if it's those requests for modifications, you can actually call us and call our helpline. We're working through those modifications, so we can help fill them out for you. All right. So with that, and if we don't get to your question right now, remember we're going to have a larger Q&A section at the very end, so stick around. I promise we'll get to it. Okay. So again, we filed the petition, we've gone through service, we've gone to the first court date, made sure service was proper, we've established paternity. Now, how do you calculate child support? Next slide. Well, the court's going to try to base child support on a party's actual income, but this can only happen when the parties appear, when they're showing up to court on time and they're seen by the magistrate, and they provide credible or believable evidence about their income. Now, if the parties don't appear, what happens if the respondent doesn't appear? If the respondent doesn't appear and if the respondent doesn't appear, then they don't show up to court on time and they're seen by the magistrate, then the support magistrate can move forward without them. Remember, we said that was service. So if they don't show up, the support magistrate can issue a default order and end up imputing or assigning income to them that may be much higher than what their actual income actually is. But what about credible and believable evidence? What is this? Let's go to the next slide. So the summons and petition that you'll receive when you file the initial petition, you'll receive back a summons and petition, and when you're served, you'll get a copy of these. Look through these. These have all of this listed: the financial disclosure affidavit, the tax returns, the W-2 statements, letters of employment. All of these are really important to bring in. And the financial disclosure affidavit is attached to that summons and petition. The FDA financial disclosure affidavit is something where the parties fill out their income and expense statements and their actual income. This has to be signed and notarized by the person filling it out. And be sure to get it notarized before coming to court, because there's no notaries in court. And we said before that the court can impute income to you. Well, they can also do something called a needs-based order. And a needs-based order is common when there's a public assistance case, when the Department of Social Services has started a case. And the court will enter what's called a needs-based order based off of the public assistance budget letter. This will assign the child support order based off of how much the public assistance that the child is receiving. An imputed income, where the court can assign a child support order if you don't appear or you don't bring any of this evidence, enough credible or believable evidence, the court can impute your income and assign it to you. But what are they basing it off of? Well, it can be based off of former resources or income. Like if Robert was making a certain amount of money in the past, but he either quit or lost his job, the court might be able to impute income to him based on what that was. And this could be for the custodial caregiver or the non-custodial parent. The support magistrate could also impute income based on property, like cars, boats even, or even bank accounts. Next slide. This is the child support calculation chart. This is what the court uses to calculate the base amount of child support. And this is based on statute or law. So for Robert and Maria, they have 2 children. So the court is going to put the child support percentage of 25% onto their combined income to get the base child support amount. But remember, there are add-ons on top of this 25% for health insurance, health care, child care even, things like that. Next slide. Remember in the beginning where we said you can't calculate child support all in one day. What does the court do if they can't do that? Well, sometimes they issue what's called a temporary order of support. And this tries to be as close to the final order of child support as possible. It's from the non-custodial parent to the custodial caregiver or to the Department of Social Services until the next court date. Now, when we were talking about imputing income, and it could be based off of former resources or income or property, the court can also impute or assign income to you if a party is working less than 35 to 40 hours a week or full-time. The support magistrate may require a party to find full-time employment at 35 to 40 hours a week, and that can be done through something called a job search diary, where you're recording every time you're looking for full-time employment. And the support magistrate may even refer someone to the STEP program, which is a jobs training program that can help a party find full-time employment. Next slide. Okay, so how do you pay your child support order? Well, a non-custodial parent can pay either directly to the custodial caregiver, or the default way generally in New York is to pay through the Office of Child Support Services, OCSS, and it's commonly referred to as the SCU, Support Collection Unit. Now, Hilly's going to talk a lot more about the support Collection Unit, OCSS, at the very end when we talk about our resources, but I really want to highlight some of the benefits of paying through OCSS. So they keep track of all the payments that have been made, and you can get free printout, like payment printouts of every payment that you've been making in court. And you can also set up an account online and keep track of all of the payments that you've made. Next slide. The final order. What happens with the final order? Ryan was talking in the beginning about preserving a really important date, and that is something called, it has to deal with retroactive support. And what retroactive support is that the child support order will be retroactive, or will go back to the date that the petitioner files the petition or when the child started receiving public assistance, depending. This will result in the non-custodial parent generally owing some arrears or unpaid child support. But it can also end up having, if there's a temporary order, the non-custodial parent may end up with a credit. And we'll see, we'll delve into this more on the next slide. So let's go to the next slide. So there's two ways that it really can end up working with that final order, the last court date. It can end up with the non-custodial parent automatically owing some arrears, unpaid child support, or they might be issued a credit. So let's work through arrears first. If the non-custodial parent has been paying less than the new or the final order since the petition was filed, then generally the court's going to have this non-custodial parent pay off those arrears a little bit at a time. And usually it's 50% of the final order on top of the court order. So what does this mean? How does this work? For example, if Robert was ordered, his final order was to pay $250 per month. His final order could end up being $375 per month. That's $250 plus $125, half of the $250. $125 is going to go straight to the arrears until they're paid off, which will end up with Robert paying around $375 per month until those arrears are paid off. But what if Robert was paying Maria directly through money orders during this proceeding, or through Zelle, through Venmo? What happens then? Well, maybe, or if there was even a temporary order issued, Robert may be able to get a credit for those payments and owe either less or no arrears at all. Next. Next slide. Okay, we've gone through this final order. We've gone from the beginning, before we even start a court case, to filing a petition, making sure that the non-custodial parent, the respondent, was properly served through the first court date, established paternity. We've calculated child support and maybe had a temporary order. We've gone through this final order, but what happens if you don't agree with it? If either party disagrees with this final order, then they have the right to file what's called an objection. This requires the court to look at the facts of the case again, the findings of fact. Next slide. This is not something where it's not another court proceeding. It's something that the parties are going to fill out and say, I disagree with this order. The support magistrate should have considered X or Y, whatever they should have considered, and they didn't here, and I disagree with it, or whatever the reason for disagreeing with it. The parties are going to end up receiving a letter from the court with the judge's decision in that. I want to highlight, this is really important, that you only have 30 or 35 days from the date the court order was issued, if it was mailed to you, to file this objection. So you have to do it within 30 to 35 days after that court order. All right. Next slide. All right, let's take some questions before I hand it back over to you, Ryan.
Okay, so there are a few. The first one we'll go with, if the children are different ages, does that change how child support is calculated?
Kind of. It can. If, say, remember when we were saying that a child support order goes until 21? Well, if, and Ryan's going to talk about this a little bit more on the next slide, then if the older child turns 21, the court order is going to be modified to only reflect the children under 21. But if it's, a 14-year-old and a 16-year-old, it's going to be generally the same. It can vary with the add-ons though. So typical lawyer answer, it depends.
The second one is, if the non-custodial parent is working off the books or getting paid cash, how do you prove their income?
That's a really, really good question. It depends on what's going on, but possibly a letter from their employer. Everyone has to fill out that financial disclosure affidavit, that packet or piece of paper that was attached to the summons and petition that's signed and notarized. Everyone has to fill that out anyways. But if you believe that the other parent isn't truthfully disclosing their income, then there may be ways around that, possibly a subpoena. And call our helpline for this. We can get into more of the specifics there.
All right, and just one more, because I know this is a pretty popular question. Does the court take into account the expenses of the non-custodial parent when making the calculation?
Possibly. Where the court can take into account the expenses of the non-custodial parent is when the non-custodial parent is paying a separate child support order. But generally, that's about it.
All right. I mean, there are a lot more, but we still have a lot to cover, so we're gonna have to save those questions for the end.
All right. I hand it over to you, Ryan.
Okay. Well, my turn. So this part, first we're going to talk about child support modifications. And modifications are petitioning the court to ask for a change of some kind of final child support order. And both the non-custodial parent and the custodial parent can both file for a modification of a final order. To me, this part is probably the most important information to remember. You can always go back and look up the calculations or how things work, but it's important to remember how modifications work and when to file for a modification, because it can have some pretty drastic effects not knowing that information. So let's get into it. Next slide. So first thing to know is, when can you file for a modification? Well, generally you can file a modification if it's been 3 years since your last order was made. So that's either 3 years since the order originated or when your last modification was made. But for most people, they're going to fit into the second category. And that is if there's been a substantial change in circumstances. And let's talk about what a substantial change in circumstances means. Right? It's kind of a legal term. Next slide. So, substantial change in circumstance could be a child moves out of the house and moves in with a different adult. It could be an emancipation event, such as the child joining the military, they get married, or they turn older than 21. In those circumstances, they're considered to be emancipated. They're considered to be an adult in the eyes of New York State. Something that gets asked a lot is, is there a form that they have to sign to be emancipated? Not in New York. New York, it's just an event that occurs. And I would, Molly touched on this in a question that she answered, for the child turning older than 21. Now, usually, if you have one child on the order and they turn 21, the order will end on its own. What we're talking about here is if there's more than one child on the order. So let's say Robert and Maria, right? They have their 2 children. The older child turns 21. The younger one is still under 21, right? They're not emancipated yet. Well, the order does not change on its own. The order is going to stay the amount for 2 children until either Robert or Maria go back to court and file for a modification to have it be adjusted to the amount for one child. The other circumstances are if a parent becomes incarcerated, or if there's been a change in employment. And I imagine, especially with the lockdown, a lot of people have been going through this. Right? Whether it's your clients, friend of yours, or yourself, a lot of people have lost their jobs recently, and it had a big effect on child support. This has been mentioned a couple of times now. I'm sorry if everyone's sick of hearing it, but it's very important. Right? The reason to know about modifications and to take action early is because the court can only put their order into effect back to the date the change was filed for. Right? So let's say Robert lost his job, and he lost his job on June 1st, and he doesn't file for a modification until August 1st. Well, there's 2 months there that he wasn't paying child support. And unfortunately, because he waited, the court's not going to be able to give him credit for that. If he had filed on June 2nd, then he would get all that time period covered if the court modified it in the end. So next slide. Let's talk a little bit about loss of employment. Right? Just because you lose your job doesn't mean the court is going to modify your order. First, you have to file that modification. Right? A lot of people think, well, they're taking it out of my paycheck. They know whether I have a job or not. So the order will change automatically. It's not true. It's on you to go to court and file for that modification. The second thing is, it depends on how or why you lost your job. And let's dive into that a little bit. So there are kind of two categories. The first are foreseeable circumstances or changes, and the other is unforeseeable changes. So foreseeable means things that were in your control, things that you could have stopped. Unforeseeable changes are things that happen through no fault of your own. And to help us illustrate this, the difference between the two, we're going to look at two different people. So we have Lewis and we have Erica. Lewis has been paying Rosalba child support on time since the child support order started. However, he recently lost his job because he was hurt. His doctor says that he will not be able to work for 6 to 7 weeks. So he's not paying. Erica has a job as well. She just received a child support order from the court and thinks it's too high. So she quit her job and is going to look for a different job that pays a little less so she doesn't have to pay as much child support. And we have a poll. So based on those situations, do you think Lewis's situation was foreseeable or unforeseeable? Do you think Erica's situation was foreseeable or unforeseeable? Remember, Lewis was hurt on his job, and Erica quit her job. So 94% think Lewis's situation, was unforeseeable, and Erica's was foreseeable. And those are the right answers. I mean, Lewis was hurt. He couldn't, help that, hopefully. So because of that, he can't work. Other unforeseeable circumstances would be you get laid off, right? The company's downsizing, or maybe there's a lockdown, right? And they close up shop and you can't work anymore. Erica, though, she quit her job. Right? In that instance, the court would likely tell her that it was foreseeable she would have a hard time paying that support. Another kind of foreseeable event would be if you kept coming into work late, right? And you didn't quit, but you got yourself fired. That would be kind of a foreseeable circumstance And so unlikely that the court would modify your order. Let's go on to the next slide. So let's say Robert, he had filed the modification right away, and he was hurt on the job. You know, it was a unforeseeable change in circumstances. What's going to happen? Right. Well, even in an unforeseeable change in circumstances, the court probably is not going to modify it permanently. They're more likely to grant you what's called a temporary modification. Right? They're going to, say, all right, you're hurt. The doctors say you can't work for 6 to 7 weeks. Well, hopefully you'll be better by then. So we're going to set a court date for that time period down the road, 6 months from now, right? And when you come back, hopefully you're better and you're working again, and we'll put the child support back to where it was. What happens when you lose your job? Well, kind of the same thing. They're going to expect, if unforeseeable change in circumstances. You have a letter from your employer saying, yeah, we had to let him go. Wasn't his fault. Well, they're going to expect you to, be looking for new jobs or be filing for unemployment. Show that you're taking active measures. You're not just kind of sitting back, because they're going to expect you to get a new job. And on top of that, I should note that the new job should be paying at the same rate, not a lot lower. The extreme example would be, if a doctor lost his job and then, he decided he didn't want to be a doctor anymore and he instead wanted to work in a minimum wage job. Well, the court's going to say to him, based on your work experience and on your education, you could be making more money. We're going to hold you to that. So, if you do get that new job, it has to be at the same level as the old job. Right. Next slide. So are there any questions? I'm sure there are.
There's so many good questions. Okay, give me 1 second. Are backdated modifications prorated by the day or month? So for example, is there a difference in how much our recently unemployed example will have to pay if he files for a modification on June 2nd versus June 28th?
I'm not exactly sure. I mean, I guess it might come down to when they get paid. But we'll go, so I'm not quite sure on the question, and I apologize. But, the date that they filed kind of in mix with the day that they were supposed to be paying. There are a couple of dates there, and it might be a little bit confusing for people, but yeah.
Yeah. Sorry, Ryan, I started you off with the tough one.
It's okay.
Okay. I'm going to save the rest of the questions for either after enforcement or at the very end.
Mm-hmm. All right. So enforcing child support. What does it mean to enforce? I saw a question in the Q&A earlier that asked, if the other parent's not following the court order, they're not paying, what do I do? Right? And this is the answer. Right? You can file for enforcement, file a violation petition against the parent for not complying with the court-ordered child support. And here's how child support is enforced. Excuse me. So, a little bit of background first. Unpaid child support in the law they're called arrears, right? And one thing to know is that arrears are difficult to change, right? And this gets back to why it's important to file for a modification when things occur and not down the road, right? Almost everyone starts off owing arrears, right? Just because you owe arrears doesn't mean you're a bad person, doesn't mean you're a bad parent. Arrears are applied, at the beginning of every child support case retroactively. Most people start off owing. Right? Typically, they're not expected to be paid off all at once. Right? People come in and say, I owe $20,000 in arrears. What am I going to do? Well, you're going to pay them off a little bit at a time. Right? And that's how it works. When things are going through the support collection unit, they add 50% or whatever the order is to the payment, and that goes towards the arrears. So the example here is if you have to pay $100 every week, then you're going to be expected to pay $150 every week. That half amount, $50, is going towards the arrears that you owe. Next slide. All right. So how, like I said earlier, it's very difficult to get rid of arrears, but there are some ways that they might go down. If they're owed to the custodial parent directly, right, the only way for them to go down is by paying them or the custodial parent willingly forgiving them. The second is if they're owed to the Department of Social Services in New York City specifically. I know we have a lot of people here, it might be from across the state. But if they're owed to the Department of Social Services in New York City, there are some programs through OCSS that can be applied for to manage those arrears, to get them lower. And we have contact information at the end of this presentation about how you can reach out to them and ask them about their arrears cap program. That's the big one. But because it's difficult to modify arrears, you know, these are the only ways. It's important to remember that modification process. All right, next slide. So we're going to get into the enforcement mechanisms that the law has, but I want everyone to keep in mind, you know, the goal of enforcement is not to punish. Right? It's not just to send people to jail. Right? The goal is to be able to get the money for the custodial parents so that they can spend it on the children. Right? The next slide. Right. So a couple different things. If child support is being collected through the support collection unit, right, it's coming right out of someone's paycheck, then there are a number of things that can happen automatically without anyone having to go to court. These are called administrative enforcement mechanisms. For any of these to happen, they can happen on their own. And if they do happen, there are different things the non-custodial parent can do by talking to the support collection unit to try and undo them. And we'll go over them now. So first one that happens is if 4 months or more owed, SU can suspend a non-custodial parent's driver's license. Now, as far as what the non-custodial parent can do, they can, if they need a license to go to work, they can go to the DMV and get a restricted license, or they can sign up for a payment plan with the support collection unit. Now, we'll say, when you're signing up for the payment plan, it is not a negotiation. The plan is that you will pay the order in full and on time. So if you know that you cannot pay it on full and on time, consider going to court for a modification first, so you can get it down to a level you might be able to pay. Next one. They can suspend your ability to get a new passport or to renew a passport. They cannot take an active passport away. If for some reason you need to travel outside the country, it's going to be very hard to get an exception. There are a few, but you'd have to reach out to SCU to talk to them about that. Next one. They can freeze your bank account. And not only can they freeze your bank account, but they can freeze any bank account with your name on it. So if you have a joint bank account with somebody and you owe over 2 months and $300 or more, they can freeze that too. Now, there are some few exceptions for freezing bank accounts depending on your income level, but again, you have to reach out to SCU. These things cannot be undone by the court. And the last one is the interception of tax returns. So if you owe $150 or more, SU can intercept your tax return. And kind of in the same light, some of you may have experienced this or heard about this, the stimulus check that recently went out, or people might be waiting for, that falls in the same category and can be intercepted to satisfy arrears that are owed. So those are all things that can happen automatically. Right? And the family court can do all those things too, but usually they are handled by the support collection unit first. There are a few things that only the court can do, right? And this is where filing the petition for enforcement or violation comes into play. And so when you file that, you get a court date and you go in front of the judge. And there are two things that the judge can, the magistrate, excuse me, can do. First is they can issue a money judgment. A money judgment is a statement of the total arrears that are owed. Okay? It is not expected to be paid back all at once. And so sometimes people will get a money judgment for $50,000 and they'll be thinking they're going to get a check for $50,000 soon. That's not the case. What that statement does, or it can do, is if you had a money judgment, you can register it with the city clerk's office, and a lien is placed against the non-custodial parent. That means once that's registered, if they come into money from a lawsuit, if they come into money from lottery winnings, or they sell any kind of property, then that money is going to be intercepted to satisfy that money judgment, that lien. Likewise, money judgments start building interest, about 9%. So it can be a good incentive to get that paid off sooner rather than later. The next one that only the court can do is hold what's called a willfulness hearing. And this is kind of the last card that can be played. I mean, it's the most serious, and that is because the result of a willfulness hearing can mean that the non-custodial parent faces up to 6 months of jail time. But remember what we said, the point of a willfulness hearing is, or the point of this process, any enforcement process, is to get the money, not necessarily to punish. So there are a couple of outs in place. Let's talk about how this process works. Next slide. So in a willfulness hearing, a couple of things to know. The non-custodial parent may be offered a court-appointed lawyer. That's because they're facing jail time. Their liberty's on the line. Custodial parents don't get a lawyer in these situations. But you should know that this lawyer is there to talk about whether or not there's a willful violation, right? Whether or not incarceration should happen. You're not there to help argue for a modification or to change the amount of money that is owed, right? Just to talk about the jail time. So what does this hearing look like? Well, they're looking kind of for two things generally. If the non-custodial parent is working, are they willfully choosing not to pay? Right? If the non-custodial parent is not working, are they willfully choosing to not look for new work? I mean, this is kind of where the first out it happens. Right? If they have a job and they're just choosing not to pay, if they start to pay, then they can avoid going to jail. Likewise, they're not working. The court may put them in a job placement program. They might have them fill out a job search diary. They want them to start looking for work, and they're going to encourage that to get the money, right? Because if someone goes to jail, they're not going to be able to pay child support. It's not really going to help anybody. Let's say, though, that those things don't happen and a willfulness determination is made. Well, it's going to be referred to a judge for incarceration, and they're going to set what's called a purge amount. This is the second out. A purge amount is a certain percentage of what is owed in arrears, and that's going to have to be paid up front. If they pay that amount, then they can avoid being incarcerated. If for whatever reason, though, they do not pay that amount, and they don't start paying child support, then the judge can incarcerate them for up to 6 months. All right, next slide. All right, so that kind of brings us to the end of the enforcement slides. We're gonna just do a little bit of a recap here for everybody. The family courts currently are not hearing child support cases, but you can put in requests for a modification, and the courts will start processing those soon, hopefully. But the dates are not being set. There is a link here for more information about that. Likewise, you can call our helpline for assistance in filing those requests. One thing to go over, since the courts are not hearing child support cases right now, we don't know when they are going to be hearing it, right? But for the time being, if you don't have a letter for your employer, or your client doesn't, tell them to get that, right? It'll be important down the road, right? They're going to want to see why they lost their job. Hold on to proof of unemployment benefits. The court's going to want to see those things. If you are paying, keep receipts always. Pay as the order says you're supposed to pay. So if it's through SCU, pay through SCU. And if you're the custodial parent and the other parent's not paying, keep track of all the missed payment amounts and the total of the amount that's due to you. All right. So I know we are running low on time. I'm not sure, Hilly, if we want to wrap up, or we're going to answer some questions right now.
So we are running low on time. We're going to take one or two more questions right now.
Okay.
But for everyone watching, thank you again for coming. We're running a few minutes past the 4 p.m. Our webinar will be posted on YouTube if you do need to go, but let's keep going. Couple questions. Give me one sec. Okay. You talking about the bank accounts and freezing the bank accounts when child support is owed, when there's arrears. Do they only, oh, sorry, it keeps running away from me. Do they only freeze the exact amount owed and then take it out, or is the whole account just frozen?
That's a really good question. They freeze the whole account. They will freeze the whole account, but they should only take out what is owed. As far as unfreezing the account, I think that's something I skipped over. But reach out to SCU. They're probably going to want to see the most recent bank statements and also most recent pay stubs. Usually people run into trouble when they're not working, right? So they freeze a bank account. But if you can show them you are working and that you're going to be able to start paying, it can help.
Awesome. And then I think this was something that came up in the chat, but do arrears, if the older child turns 21, do the arrears just go away?
That's a great question. Answer is no. Child support arrears will stay pretty much forever, even after the point of the child turning 21, right? The way to kind of look at it is that money is owed to the parent of the child for the child. And if they didn't have that money for when the child was under 21, they had to spend their own money, right? So it's still owed to them.
Awesome. Thanks, Ryan. I think let's hand it over to Hilly to go over some resources, and then we'll finish with the questions at the end.
Yeah, I'm excited to answer those.
Hi, everybody. I'm back. So a couple things before we get to the extended Q&A. Where to go for help. So the Office of Child Support Services, OCSS, Ryan and Molly have both mentioned them. They, as you know, help people receive child support. They can help with collecting it, and they also can help non-custodial parents or non-custodial caregivers with finding a job and getting connected to other services if they need to. Just so you know, OCSS doesn't help with custody and visitation, but they can guide you to services that do, including mediation. And another important note, you do not need to be a US citizen to sign up for services at OCSS. They will not ask for immigration status when you go, so we just want to make sure that you're aware of that. To get in contact with them, usually you would be able to go in person to their customer service support center, which is at 151 West Broadway. We didn't include that address on here though, because right now, of course, in New York City, we can't go in person to businesses. So some other ways that you can get in touch with them to ask your questions is to call 311 and ask for child support. You could call the New York State Child Support Helpline, or you can email OCSS directly at this email here. One note on that, if you do email them, please include your child support account number so that they can fully respond to you. All right. The next place that we want to highlight is the Interstate Child Support Unit. We didn't get into interstate child support cases in this webinar. They are complex, but so we want to make sure to direct you to ICSU if you have questions, and also to let you know that they're here and they exist in New York. So what does ICSU do? Oh, sorry, I just lost my place. All right, thank you. So if the custodial parent lives outside of New York State and has opened a case with their local child support agency wherever they live, ICSU will appear in the New York Family Court on behalf of that child support agency that's in the other state. All right. If the custodial parent lives in New York City and the non-custodial parent lives outside of New York, ICSU can help with, services for filing that petition, or whether it's a child support petition or paternity or the modification, or even enforcement of an order. They can also help with that. An important thing to highlight right now, ICSU is remotely processing interstate child support petitions on behalf of custodial parents who live in New York City. So if you are a custodial parent in New York City and the other parent lives outside of New York, ICSU will likely be able to help you. A few ways to get in touch with them. The first and most important is if you think that you want to connect to ICSU or they might be able to help in your case, you want to talk to OCSS, because OCSS will provide that referral to ICSU. If you have questions for ICSU, you can also contact them at the phone number on this slide at the law department, or you can call the New York State Child Support Helpline, or you could email them at one of these emails here, depending on which borough or county you live in. And they provided us these emails to share today during the webinar. So thank you to ICSU for that. All right. And last is us, LIFT. So legal information for families today is also here for you. Our helpline is available for anybody to call. We can answer questions about New York State family law and family court. So just so you know, it's open Monday through Friday, 9 to 5, and we're closed an hour for lunch from 1 to 2 p.m. We're operating fully remotely right now. So we also are able to give legal advice. Our attorneys can give legal advice through a consultation, an hour consultation over the phone right now instead of in person. So if you have a case of child support, custody, or visitation, and you do not have a lawyer representing you already, you can call our helpline and they might be able to schedule that appointment for you. All of LIFT services are free. We don't have any income requirements, none of that. We serve everybody. So please reach out to us if we can help you or someone you know. Please share information. We also have a library of legal information guides on our website, and this third bullet point here has our website listed. These legal information guides explain the basics of family law and the court process in New York. We have one on child support that explains how it's calculated. We have one on child support to explain modifying a child support order. So if you'd like to refer to that resource or share it with somebody, you can access those on our website, and they're available in multiple languages. So I know we're running over 4 p.m. Thank you to everybody that has come. If you would like the slides for the presentation, please complete the feedback form, and I will be posting the feedback form in a second in the chat, but it's at this URL here, and we will be emailing the slides to everybody that submits feedback. And we're gonna wrap up now. Thank you so much for coming, and we're gonna transition into the extended Q&A to get to all of your questions.